If you don't know me, I'm Colin Crawford. I'm on the faculty. And if you read the flyer carefully, you might have thought, why does the Payson Center for International Development, which I direct, which is part of the law school, why is it sponsoring this event? It doesn't really make sense. The Supreme Court is not typically within our purview, and that is true. We are a co-sponsor of the event along with the American Constitution Society. And it's nice to, if I can make a nod to my former student, now lawyer, Laura Avery, who was the past president, and to thank Tegan, did I pronounce it correctly, the current president of the American Constitution Society. We're a co-sponsor of the event because I'm very proud to say that Jess Bravin is a friend of mine for many years. He was here yesterday for an event on Guantanamo, a subject he knows a lot about, as discussed in his book Terror Courts, which is for sale after the event, if you'd like, right outside, and I encourage you to look at it. Jess and I first met when both of us had lots of curly hair. I'm not kidding. He had more, I'm older, so he had more curly hair than I did then. As you see, time has changed. He was a student of mine, actually, in a history section I was teaching to pay the bills while a law student, and was instantly, of course, the scarily smart student, smarter than any of his professors. And we became fast friends after that. Subsequently, my employer, actually, when he started at the Wall Street Journal, where he now still is, when he was in charge of the Wall Street Journal's California edition and hired me, I was living in San Diego at the time, hired me as a sometime stringer, to which I'm grateful because I had the best editing I have ever received on anything I've ever written. And that's absolutely true. And he's gone on to a very distinguished career subsequently, having degrees from Harvard College, and then as a law student at Bolt, he was the student regent on for the University of California system. Still should have written that book on the education system in LA. It was a terrific proposal. So has gone on to distinguish himself now in one of the plum jobs, of course, in law journalism as the reporter for the Wall Street Journal who covers the court. Since I don't closely follow the court outside of my area, I thought who better than to lead this discussion, and it's going to be a discussion, than my colleague Amy Gajda, who is herself a former reporter, and as many of the students here will know, and certainly colleagues will know, also writes about law and the media and thinks a lot about questions of law and the role of journalists. So without further ado, I'll turn it over to Professor Gajda.
Great, thanks, Colin. And of course, I'm taking this opportunity. What I'm going to do is ask a few questions, especially as related, probably a lot of students in here won't be surprised to hear, especially as related to privacy. So I'm very interested in privacy at the court, secrecy at the court, what you know and what you don't report, and issues like that. So I'm going to ask a few questions along those lines, and then we're going to open it up for public questions as well. Does that sound good?
Oh, absolutely.
Great. So I guess my first question is, how well do you know the justices?
Well, there are 9 of them, and then there are 3 retired justices, and certainly I can recognize them all by face and voice. It varies. Some of them are more outgoing than others. I would not say I'm personal friends with any of them. I've not been invited to poker at the chief's house or anything like that. But they most of them recognize me, and if I have some reason to want to talk to them, I can usually get them.
And how would you do that? So you can actually call their chambers and then have them eventually pick up?
Well, it varies. For instance, for a story I was working on, there was a particular issue I wanted to run by Justice Scalia, and I knew he was going to be speaking at an event, and I just thought it would be easier just to go to the event and go up to him and talk to him than to put in a formal request for an interview, because that's one way to do it, and that worked. I just went out and walked out and told him what I was doing, what I was interested in, and got a comment from him. So.
And he would be probably one of the justices who is most amenable to such a thing, I would assume.
He's not shy. So yeah, he feels like it, but he doesn't feel obligated to either. And so there are different ways. I mean, basically, the more formal the interaction, the more likely I am to go through a written request through the Public Information Office and other aspects. Some justices just have a kind of formal dialogue through email or occasional other mediums. So I would say it varies, but there's a book that came out a couple of years ago called Justices and Journalists, and I saw it in the book, and it described the relationship between the press and the court over the past couple centuries, and it seems like they had a lot better if you were a reporter years ago, when the justices actually would invite reporters over to play poker in their house, and would have a lot more interaction with the press corps informally, much as they also had more interaction with the political branches. I mean, those also were times when they gave advice to the president and had much more involvement, I can say, with society at large than being as cloistered as they are today.
So I would assume that you know them better than perhaps a lot of people in this room. So what one word or two would you use to describe each justice? Justice Scalia.
Pterodactyl. I don't
So in other words, if we want to come to understand what the justices are like as people, which is, I think, oftentimes what the justices don't want us to come to realize, because they are so standoffish, oftentimes with media and others. Do you have a window into their personality that we may not understand?
Well, I mean, certainly by proximity, yes. I mean, you see somebody a lot, you watch them, and most of the time that I'm in the same room with a member of the court, I'm just watching. I mean, whether it's an oral argument or whether it's one of these periodic events that take place in the social calendar of the court. There are various things that happen inside the court or related to the court where one or more justices might attend and they may or say something. So usually I'm just watching. So yeah, you get to watch and see how people act at different occasions. I'll actually recommend, if people are interested in a window about what they're like when they don't think people are really watching, it's on C-SPAN. A few years ago, Justice Thomas published a memoir called My Grandfather's Son. And there was a book party held at the home of his friend Armstrong Williams on Capitol Hill. And as a mark of his commitment to transparency, Justice Thomas invited C-SPAN to come and record the event. And it's almost like found art. It's like basically just a camera there that's running at this cocktail party.
Wow.
And you see members of the court and other people, some of them quite famous or powerful people, chatting, looking over the tray of hors d'oeuvres, making small talk. You get to sort of see them for an extended period. It's a party. I mean, it's not inside your bedroom, but it's a fascinating thing. So if you want to get a sense of what they're like over kind of a extended period, I'd say it's on the C-SPAN website. You can find the Clarence Thomas book party and then watch it. Really, I watch it several times a year.
Do you know secrets about the justices that you do not report?
Secrets?
Yes.
Well, I mean, I know things that I do not report. When you say secrets, I mean, the main gauge of whether something would be reported is whether it is newsworthy. So I know lots of things that are not newsworthy. And part of the job of a reporter is sifting through all that and finding out the essence of what matters and telling it to readers. Like, why should someone care? So
here's an example. I mean, I would guess that probably a lot of people in this room, being a former journalist, would want to know if a justice was having a love affair with, let's say, a Supreme Court correspondent. Would people want to know that? Would anybody want to know that here, seriously? there are some people, and I think there are some people who are hesitant to raise their hands. They would want to know something like that. I would assume, talking with the Supreme Court correspondent for the LA Times, who said he would never report such a thing. So that information was just completely off limits. It was not newsworthy. Would you agree?
David Savage, a great reporter, and it is so far beyond the realm of my imagination.
And yet, it was alleged to have happened about 20 years or so ago.
I wasn't there at the time. Let's see that's a tough one to say. I mean, I guess the question would be, what, that's happening, and then the next question is like, so what? I mean, there really are two elements. One is that news is a competitive industry, so if I learn something, sitting on it and always raises the risk that it will get out through some other medium. And how would I feel if a competing publication published that information? I don't know. I mean, the question would be, how is that related to the public interest? For instance, is it skewing coverage? What if it was some other public official, an ambassador or a member of Congress or something? Would that be newsworthy? I guess I'm trying to think, like, what would the lead be? How would you write the lead?
Well, I would work for People magazine, and I would write the lead something along these lines. I don't know. Married justice, love affair. I can't even remember. Yeah, I can't remember which.
Married.
Yeah.
Well, I guess I think that it's one. It's it's certainly not happened since I've been there, and it is sufficiently sensitive and complicated that I would definitely bring this up with my editors, and I would say, here's what's going on, what should we do? Because that is, whether to publish information like that would be a decision that we made at the highest level of the news organization. And if I found that out, depending on the circumstances by which I found it out, I mean, there's certain ways you learn things and you can't really, you're not supposed to use it. But if it was, usable, I think, yeah, we would have to have a discussion, because it may be, it may affect the, matters of public interest and public trust.
And it is sort of interesting in like First Amendment media cases, maybe. So maybe you could make that argument, conceivably, if the court's hearing today. And along those lines, I'll ask one more question about personal lives of justices and how you would respond. And that is, if one of the justices had had an abortion, or the justice's wife had an abortion, would you report that information?
Well,
because my goal here is to try to get something that is like newsworthy, because that actually the court will hear cases like this. So,
I would say again, it depends. I mean, it's hard for me to think of. News is a very relativistic endeavor, and what makes similar events newsworthy and others not newsworthy depends a lot on the context. For instance, if there was a case involving abortion rights and we came across this sort of undisclosed information, I think it would be it might be very relevant. Or if it's a case about ERISA, I don't know if it's necessarily relevant. But again, there are always going to be abortion cases coming, so it will. Part of it depends. How do we learn it? I mean, one thing about the the mainstream media, at least where I work, you can't. It's not like the police. You can't lie to people. You can't break into their houses or hack their email, at least in this country. So there's certain rules about how you can learn things, and so how that information came, how I came across it would be relevant.
So one of the places of secrecy, as you know, at the court is with the clerks. So clerks to the justices who then, this was a description published by one of the clerks just a few years ago. The Chief Justice stands at the front. We shift nervously in our seats. We are asked to stand and take an oath. After we have sworn to uphold the values of the institution, we are invited to sit down. The Chief begins a long speech. What goes on inside these walls is secret. It is not for public dissemination. You may never, ever tell anyone about your time here. What we do here is private, under seal, and not for the public's eyes. To the extent that the media wants to talk to you about your job, tell them you have no comment. And if there's ever any question about a leak, come straight to me. If you fail to abide by this oath at any time for the rest of your life, your professional career may well be over. So is there that level of secrecy then at the court? And I don't know, and I assume that's rank list, but maybe not. So is there that level of secrecy within chambers?
Chambers are very secretive. And there is not, but in some ways the institution is different and it's covered different than, say, the Congress or certain other public institutions. They are very secretive, but there's also much less effort on the press corps to get inside those chambers, because the kinds of reasons you would want to know what's going on inside a congressional office are not there to the same extent. Because members of Congress run for election, they seek contributions from people, they make deals over legislation, they make deals with other branches of government. There are public accountability reasons why we would view what goes on inside a political office as being probably more newsworthy than the deliberations inside a legal office. And that's one. We also were feckless. I say that for jest, but there is this feeling that the court, because the factors that influence members of the court are different than those in political offices, what we tend to focus on and what we think is most newsworthy and relevant to the readers is somewhat different. However, the chambers they're not like, members of Congress or state legislature or city council. They're constantly putting out press releases telling you where the politicians are going to be. They invite this scrutiny in a way. Members of the Supreme Court justices do not put out press releases. They do not engage with the public in the same way. We don't see their job as being the same. And we don't see it that way either. And the law clerks, it's interesting, the fascination with law clerk fleets. I think this comes from Brethren in the 1970s when Bob Woodward and Scott Armstrong wrote a great expose about what went on inside the Supreme Court. But even though they interviewed many law clerks and former law clerks for that book, which I recommend you read if you haven't, the primary sources were justices themselves. There was tremendous discontent under Chief Justice Berger. There was a lot of frustration among the associate justices about what was going on. And they were primary sources, much more so than the law clerks were. And I think that the law clerks, to the extent that they gave interviews to Woodward and Armstrong, they were taking the cue from their justices, because Chief Justice Rehnquist does not have to give a speech like that to create a sense of tremendous worshipful adoration on the part of law clerks at the Supreme Court. They come in there not saying, I'm taking this job, I've worked hard in law school and done all this so I can get here and tell everything I find out to some stranger who works at a newspaper so they can get a one-day story about some case involving water rights in Oklahoma. It's not, they're not oriented that way.
Yeah. So this is as I'm sure you know, this is actually from a forthcoming book on secrecy at the court. This is a line from the book. But on June 30th, 2014, Jan Crawford, an experienced and highly reputable Supreme Court reporter, confirmed that she had inside sources from the court explaining exactly how the vote lineup in the Affordable Care Act case came to be. Bloggers, journalists, and good old Supreme Court junkies debated nonstop about who the leak could have been. Was it a justice or a clerk or a spouse or, do you have any sense of who that was? And
well, this incident, I hope you're familiar with. This was a huge exception to the way things had worked there for the years I've been. And there was, and interestingly enough, even though think anyone doubts the accuracy of Jan Crawford's report. There were no reports that appeared anywhere else that corroborated it. In other words, sometimes if there's a major news story, we're forced to acknowledge a competitor has it, we have to follow it and match it. No one was able to do that. I don't think you'll see any stories matching. And it was, some of us maybe thought this would, create a more open-minded relationship with the press, but it has not. In fact, I'll say this: a day or two after that report ran, which, as I say, neither I nor anyone else was able to corroborate, even though I don't doubt it. Justice Scalia, who had a book coming out, and I had been scheduled to interview him. And I remember I was in California on the 5 freeway, driving through the Commerce exit, and I get a phone call, and it was like, please hold for Justice Scalia, and oh man, my ship has come in. And he said, Jeff, you probably read those reports, and I said, yeah. Well, I just want to tell you, I'm not going to talk about them when we do our interview tomorrow. Thank you, bye. So you talk about it, rubbing it in. So I think that and for that I think you've got to look pretty specifically at Jan Crawford's own history and her relationships with justices. I mean, she wrote a book in 2005 called Supreme Conflict about the arrival of Chief Justice Roberts and Justice Alito. She's so far that has been, she's not been able to duplicate that since, and that's no mark against her, but we can say this. It clearly was coming from the right wing of the court, and there were clues in retrospect to it. For instance, at the Princeton reunion, you saw that?
No.
Okay. Well, Ramesh Panuru, I hope I'm pronouncing his name right, who's a writer, I think, for the National Review Conservative magazine, he said something on an alumni reunion panel at Princeton in May about, Chief Justice, going, wobbly, something. He said something at a Princeton reunion panel, which has been reported, and it was tweeted by another Princeton alum who was there, Barton Gelman, who's a reporter for the Washington Post. And he tweeted, something about, Chief Justice switches sides, and, says Ramesh Panuru on the alumni panel. So there was a clue floating out there at the time, and I didn't notice it at the time, but in retrospect, it turned out it was quite accurate. So there were things happening. And then there were also some stories that ran, I remember there was like a bunch of conservative editorials or columns sort of attacking the Obama administration for trying to intimidate the Chief Justice, which seemed kind of weird because I thought, why are they, the Chief Justice cares what President Obama has to say in the case, and it seemed odd, like they were setting up a straw man to knock down, but it turns out that those probably were planted through some kinds of leaks.
So it sounds like maybe the court is becoming just a little bit more media savvy, maybe, or some members of the court may have decided to use media in that way. And do you think that could mean that someday soon we will have cameras at the Supreme Court? Because right now, there are no cameras at all allowed at the court.
Someday soon. Now, soon to them, it's not what it means to mortals. So I would say no. I would not expect to see cameras inside the Supreme Court chamber anytime soon. Certainly not before they are a fixture in all of the circuit courts. In terms of their media savvy, well, more of them have published books now, and then they get professional PR people who try to promote them. So, yeah, but I wouldn't say it's a really savvy. They're not the Kardashians. They're not out there finding a way to get attention for anything they want to do. My sense is that this was a particular incident sort of unto itself. I've not seen any clues since then that.
How about and then I'll open it up after this question, but how about when last term the protester interrupted oral argument, and there's video of that in the court. So there's video of the protester. So not only did the protester interrupt the oral argument, Also, somebody snuck a camera in to get video of that interruption. Do you have any sense of how that might affect the court? Were you there that day?
Yeah, well,
Yeah, and what was that like? How did the justices respond, and what do you think the ramifications of such a video might have on the court?
Well, by the way, if you haven't seen it, you can find it on YouTube still. And it probably set back the movement to put cameras in the court because what they showed was so dull that no one would ever. This was a case that was not an important case. It was not even in the courtroom. I was downstairs in the press room, and so I then heard about it. But what this was.
So do they have feed into the press room for you to hear oral argument?
No.
That's astonishing.
Only sometimes when they have overflow because of it being a very high interest case. But I could have.
Yeah.
In the building, and it was a inconsequential case, but the protester was part of the broader Occupy Wall Street movement, and he stood up to criticize the Citizens United ruling of the Supreme Court from a campaign finance ruling, and he had a Confederate who had some kind of camera he had snuck in, and he was filming it. It was in a sort of a weird angle, and you could also see the oral argument proceeding there for a while. The immediate consequence was felt by the regular press, because the next day the Supreme Court police had put in this whole kind of TSA quality magnetometers and all kinds of things that made it much more difficult to rifle through everything, and it was again sort of the wrong reaction, because the people who are least likely to break the rules are the ones who have a continuing relationship with the court and have not interest in interfering with it. We're not allowed to sneak in cameras because we're not allowed to lie and break rules and gather news. So it became much more intrusive and unpleasant to try to get into the courtroom. And I don't know if this is coming from the justices or just the police automatically reacted this way. So that was one thing. They made it more of a drag to get into the courtroom. The guy was prosecuted. There's apparently a federal law that makes it a crime to conduct a harangue on Supreme Court property. So the alleged haranguer was hailed into court, and apparently, from what I gather through my sources, these are not Jan Crawford sources, but that members of the court, at least some of them, wanted to throw the book at this guy because there's a penalty range. And the U.S. attorney who does the local prosecutions in Washington, D.C., just let him off with, I think he pled guilty to some infraction and let him off with, a suspended sentence. And there was, to the local prosecutor dealing with homicides and things like that,
haranguing, it's not high on the list.
The threat of haranguing was pretty low, and they just thought of it as like a nonsense case, particularly because there were a lot of people who were taken out of the Capitol, and the court thought it was much more serious than that. But they couldn't force the U.S. attorney to bring more serious charges. But I think ultimately it didn't have a big impact. But I will say this: you asked about relations with the justices, and once when I asked the Chief Justice if about cameras in the court, when did we see them, and he said, well, as Justice Souter once said, cameras will roll in over his dead body, and I agree with that. Cameras in the court will roll in over Justice Souter's dead body. And when the camera was snuck in there, I sent Justice Souter a note saying, so glad to know that you're still in good health. We'll be back, and I'll redo that note if you want to. If I hope I'm
trying to see the number.
No, he doesn't use email.
Okay, yeah, good point. Good point. Yeah.
He says, I sent him the clipping, an article about that. That's what I sent him the clipping before he said, thanks for the clipping about the illicit video in the courtroom. Even if I had still been on the bench, I think I would have felt free to survive. My pledge of ultimate opposition was properly understood to apply only to recording devices lawfully admitted. Anyway, as I told Senator Hatch when he expressed alarm that I put myself in undue jeopardy, a well-lived life includes not only dying from old selves, but reviving from new ones.
Okay, and on that note, I will open it up to questions from the people here. Yes.
I was wondering, I think it's well known how divided the court is, but I was wondering if you could give us like a more specific idea of how that plays out through the justices' interactions with each other.
We often see them, certainly in the courtroom, they're all sitting together. But they have kind of formalized ways of interacting. I mean, it's my impression that they're not really all friends who go, they're 9 of them, it sounds like they all play baseball on a team together. I mean, they have certain events, where their conference where the 9 of them alone sit in a room and so on. But they don't seem to interact with one another that much outside the Supreme Court building. They often are unaware of what the others are doing or what the others may have said publicly about different things. And
Does that mean they don't follow the news then as well?
They're, I would say they dip in and dip out. I don't think that, they're not walled off from it, but they're not, obsessively following everything. And, and they also say that they don't discuss cases among themselves prior to oral argument. So often oral argument is the first time they really get a sense of where the others are coming from based on the questions that come out, other than their assumptions about issues where they might have records. So, I think, though, there is this, that the divisions on the court ideologically do not really correlate for the most part in terms of their personal relations. Either they get along or they don't. They all know where they are. They don't really they don't expect big changes in the views of any others. And, famously, the closest pair on that court socially is Justice Ginsburg and Justice Scalia, who were both judges together on the D.C. Circuit before they came to the Supreme Court. They traveled to India together. There's a famous picture of them both sitting on an elephant. They both were spear carriers in a opera, because they both love opera. So, and they both will observe that, and they also will say, when I interviewed Justice Ginsburg earlier in the year, she, noted that there are certain areas that she and Scalia are totally together on, such as, the confrontation clause, and he and she are both very protective of that in a way that other members of their respective posses are not. So, I think there are, where they are intellectually does not necessarily correlate to where they are in their personal relations.
Can you tell me what would you say would make the perfect judicial temperament for being a good justice on the Supreme Court? Not asking you to identify who has it or who doesn't, but just some instances where you've seen judicial temperament perhaps was maybe not quite up to what you would expect. Indiscretion, perhaps talking too much out of turn to the press?
Well, that, you see, you and I were going in different directions there, because I would have said, perfect judicial temperament is someone who checks in with me several times a week. Feels free to, share their challenges and problems. In terms of, they're all pros. I don't have any criticism of the temperament of any member of the Supreme Court. They all are, quite smart and know, what the job's about, and don't seem sort of. I would say really, it's my job to try to tell you what they're doing, and you decide whether that temperament is where it's at. I'll say this one story I did in July was about one of the changes in oral argument that I had noticed with the advent of Chief Justice Roberts, because it sort of was a little jarring to me, because they'd be talking about some kind of really contentious case, and really, maybe there's some really ugly facts, and the chief would talk to these lawyers who were like totally going at it and say, well, your friend on the other side argued ABC, how do you respond? And I kept thinking, like, he's using friend, and what he means is blood enemy. He's using the word to, it sounded like some kind of archaic, kind of medieval thing or whatever. And so using the, now in the 21st century, we have tremendous quantitative powers. So I actually undertook this project to find out, has Chief Justice Roberts changed anything here? Because it seemed like a lot of lawyers started copying it. And said, well, my friend told you this, but he's totally full of it, because actually and so we actually did this, and we grabbed out, we have a story here I can probably find if you want to stick around that, and we showed that he totally has changed it. Now, the common term of the 5 terms we identified that would be used in this sort of construction, friend, opponent, adversary, colleague, and brother, of these terms, back during the Warren Court, all those terms were used roughly equally. In the 70s, opponent became, your opponent says, or my opponent told you, and brother dropped out pretty much after Sandra Day O'Connor joined the court. It still exists residually. But when Roberts came on, my friend went through the proof. And we have like charts showing, and showing how lawyers who never used the term started using it, and apparently there's psychological research that when there is some, person who has power over you, you tend to copy their. So in terms of temperament, the chief's good friend, Richard Lyons, professor at Harvard Law School, I asked him about it, and he studied the Supreme Court bar. He said, well, the chief is trying to raise the tone of argument and suggest that they're all involved in, common endeavor to, reach the right result. Or one could say, the lawyers are all in it together. Hard to tell. But there are ways to look at temperament, and you have to judge when you think they're meeting your standards.
Somebody's hand was up over here.
Yes. What would you make of the decision to televise the oral arguments in ACLU v. Clapper? Do you think that's a sign of progress towards eventual televisation of the circuit courts and therefore the Supreme Court, or a fluke based on the notoriety of the case?
Well, the Ninth Circuit video has video feeds of I think all their arguments. They had the Barry Bonds case was just live streamed, and that's available there too. And so I think that it may be one of these things where the Supreme Court gets a lot of attention, so they don't need to really juice the audience. Circuit courts, they don't get so much attention. Maybe they're less. Maybe they think their work is more. They need to do more to get attention from the public. You might look at it that way. I don't know. I've not actually talked to any judges on those courts about it. But when you're dealing with Congress, you've got 535 members who are in competition with each other for public attention. They try to get themselves out there. You have, a dozen circuit courts. They think what they do is important. They want to be influential. They want, they're proud of what they do. They want the public to know. They may be competing at some level for public attention about their deliberations on big cases. They think what they do matters.
So you don't think it's just a response to their sense that they are, this public institution and people don't understand enough about the courts? Because that's the argument that a lot of people make for cameras at the Supreme Court. That people don't recognize the justices, they don't understand what the Supreme Court does. Many, probably not your readers certainly, but the average person on the street wouldn't. And that by televising the court, it would actually cause people to become more interested in that branch and other branches of government.
Honestly, I think it's more a symbolic thing than a practical one. Anyone who's actually interested in learning about the Supreme Court, they put audio of all their arguments up, no later than the end of the week, so people can listen to them. C-SPAN runs them. C-SPAN Radio in Washington runs them. There are oral arguments dating back to the 50s that are on the oye.org website. There are transcripts. This was one thing that Chief Justice Roberts did soon after he arrived. He granted a long-standing request of the press corps to provide same-day transcripts of oral arguments. Those are now posted publicly the same day. In other words, everyone could reenact the arguments in their living room. The day they take place.
Does it say "said skeptically" though on the transcript?
No, but it does say laughter in parentheses.
Okay.
And so I think that people who are already interested in it, there actually is a lot of information available about the court and what its arguments are like, to the extent that, someone who isn't already interested in the court but might be flipping channels and come across it and say, this is mesmerizing. I had no idea. I think that's, actually that is how I felt when I came across that Clarence Thomas video, to be honest. I was actually flipping channels like, whoa, that looks like Clarence Thomas in that house. And it was. But I think, I think it is symbolically more significant, and also it is significant in how would that video be used. I don't think there'll be a lot of people sitting through an hour-long argument.
Exactly.
I think what you will see is that it will increase the interest of broadcast, of television media in covering the Supreme Court, because they'll have images to go with their reports. Okay, so I think that the way it will actually impact public understanding is that it will be easier for Jan Crawford at, I guess she's at CBS now, or Pete Williams at NBC, to get space on their 22-minute newscast to talk about the Supreme Court, because they will have a visual other than standing outside of the Supreme Court building to go with their report. In terms of thoughtful study of the arguments themselves, I don't think it will have that big.
But we'll get a lot of memes.
Yeah, you'll get,
And that's what Justice's worry, I think, are the memes.
I was wondering, one of the big challenges of covering court, I would imagine, is trying, especially with these really big decisions, to get the holding out quickly, balanced against, these opinions are long and they are dense and they do not always put the holding up front and they're reading them from the bench. How do you balance them? What's your strategy? How do you read the case?
Well, that's one of the aspects of covering the court is sort of the immediate flashing headlines out there when it's a closely watched case, and there is there is a tension between speed and accuracy. As you say, the best recent example was the healthcare case where several major news organizations reported it inaccurately. Same thing with Bush v. Gore in 2000. Some news organizations reported exactly the opposite outcome because they were in a rush to get something out on the wire or on the air. That it is. I understand those pressures, but I would not put something out unless I was sure it was right, even if it means not being first. Which means, in other words, if you're not first or right up there with an important breaking story, you'll get yelled at, but you get yelled at way more if you reported it wrong. So it's a question of how much yelling if you want to put up with from an editor. And it's interesting because there's a lot of focus on this part of the job. It's really, in some ways, a small part of the job, but it is one there's a lot of focus and people are looking at an outcome. Yeah, trying to get the outcome right and putting it out there sufficiently hedged is important. On the other hand, the Wall Street Journal and some other news organizations, in some of these cases, it's market booting information. And so getting it out very quickly. What does the healthcare case mean? There are a lot of stocks that whose value depends on whether or not the law is going to promote this industry or that. It's true in patent cases and other kinds of cases where getting subscribers market moving information immediately is why they subscribe. So there is a tension there, and there isn't really a rule to it, but I'd say that I remember very clearly the healthcare case, not seeing a long discussion about why the Commerce Clause does not support the government's extension of private health insurance in this way, and then the next page, but now we look at the taxing power, and I'll tell you what my clue was. The first thing I turned to in that case was the last page in the syllabus, which is the part in the beginning of the opinion that's prepared by the reporter of decisions. And I looked at the lineup of the justices, and I saw Roberts, C.J., and Ginsburg, Breyer, and I was like, that's not a lineup that I expected. So I've got to look at this really carefully about what's going on here. And that was really, for me, a warning flag to not jump to any conclusions in that case.
Okay.
Well, she asked my question exactly, but I have another one prepared. As far as know these kind of situations that may or may not exist where other National Enquirer type stories might be happening.
National what?
National Enquirer
Oh, I see.
stories are happening.
Or people, yeah.
Is it really?
Yeah.
Are you really considering your job and your continuous relationship with justice as the paramount concern?
Access. And this is a good question. This has to do with basically captive journalists. In other words, does one's dependence or need for access to newsmakers, in this case, members of the court or other people, make you pull your punches, or or do or slant coverage, or cover up for them because you're afraid of some kind of retribution or being cut out? Well, it is. I would say it's something that I'm aware of, because covering the Supreme Court, the press has a lot less leverage than covering other institutions. And the reason really is, when covering other institutions, the news subjects need the press to a certain degree. For instance, looking at a typical case of a politician, they want public exposure. They want their views put out publicly because they need to get agreement from other politicians. They know they have to respond to negative stories, because if they don't, they'll be silent and their opponents will get all the time to trash them. They need the press. To my surprise, this was true when I covered the United Nations. I thought UN, a bunch of ambassadors, half of them from dictatorships, they're not going to care about, there won't be any access. And I was totally wrong, because it turned out that at the UN, the diplomats, their whole business is just talking, spreading rumors and things. So to my surprise, it turned out that they felt it was very important to maintain good connections with the press, because sometimes they wanted to say things about other countries or send messages about other positions through the news. And sometimes they wanted to influence things behind the scenes. I found, for instance, like the United States mission was very unhelpful, very misleading often about the position of the United States government. But there are 14 other members on the U.S. Security Council, and they all would get, drafts and proposals from the U.S. And it turned out those other countries would often just give you a copy of what the U.S. sent them. It would be amazing to find out that the U.S. representative would tell you, oh, we have no position on that, or we're studying it, or we think it's very unlikely, and then to see that the actual thing they're saying is, yeah. So there's reasons, methods of some leverage. Now look at the Supreme Court. What do they want public, what do they care about? They're not running for re-election, they're not seeking campaign contributions, they're not trying to, build any lobbying effort, they're not trying to send a message to other members of the diplomatic community. They really don't need the press in the same way, and there's no threat, there's no leverage. If you don't talk, someone else will, or so. In that sense, you're at their sufferance. On the other hand, they also aren't involved in stuff in general, as far as I can tell, that raises the same kind of accountability flags. For instance, who are they taking money from? Who are they? How are they financing their re-election campaign? These things are just not there to the same degree. And the worst thing they can do is sort of refuse to talk to you, but their opinions are published and are reported. The elements of the cases that go beyond their personality are there. And so they can, they can shut you out. But what they give you when they're being friendly is so useless anyway that it's not a big price to pay. So I'd say, yeah, it's an issue. You're aware of it. I've never come across a situation where it seemed like there was a need to pull punches in order to preserve access, because the access really isn't there anyway.
Do we have time for another question, Colin? Yeah. Any other questions? Yeah.
Does the highest court in the land exist, and if so, who plays basketball?
Yes, it does exist. It does exist there. For many years, Justice O'Connor had an aerobics class that she led up there. I think that Justice Kagan and Justice Ginsburg have a personal trainer, and they go up there sometimes. And it really was, I think, established by Justice White, who was a great athlete, before he came to the court. I've actually never seen it myself. And this is what he's talking about, is there's a basketball court in the Supreme Court building. And it is above the courtroom, and that is why it is called the highest court in the land. But it indeed is there, and I guess I could ask to be taken to see it. Maybe they let me, but it's there. My brother clerked at the court, and he used it all the time. He was an athlete.
And Justice White used to take his clerks up to play, so I've actually played basketball up there. Any other questions? Yeah.
Could you talk about the evolution of the court in the near future with respect to technology? My impression is that the justices are kind of behind the times and how that might play out, with some pending cases, and if that's going to change at all.
Why ever would you think that? Well, it's interesting. In some ways, for instance, when Justice Breyer was talking about radio, we made some reference to, favor me and Molly or something. So there's Google it. In some ways, and actually, I think actually in the press maybe we exaggerate their fuddy-duddiness because it's kind of amusing. I think to get a sense of where they're at technologically when they're being serious about it would be to look at the Chief Justice's opinion in the cell phone cases that were decided a few months ago, where I think you can see an extremely up-to-date and sophisticated understanding of the role of mobile technology. They have to often decide cases which are high-tech cases, not in sort of the funny way, like, gee, what is this object? But more in the sense, things that most of us may not know that much about, like cloning and very complicated patent cases of what is obvious to a person who's skilled in the art that is being developed. Yeah, they're not. I mean, I would not say that they're early adopters as individuals, but they're not totally out in the weeds. And in fact, one way in which they do keep current is that this infusion of law clerks who are in their 20s, and I'm sure it's a remarkable transformation where the squarest people in school suddenly become the hippest people in the world. So they often are a conduit to, I think, more recent technological innovations. But in the Riley case in California that the court decided, look at that opinion, and I think you'll get a sense that when they're being serious about it, they understand what's happening in individual lives, or at least they have been told and can empathetically grasp it.
Right. So we'll take a final question.
And if I could say one more thing.
Oh, sure, yeah, of course.
Final question. It doesn't have to be final.
I guess I'll ask then. I'll ask the question. That is, what does this next term look like? So I think there's a Facebook case that, referring to that question. What do you think? What do you think is sort of going to be the most important case that the court decides?
Gay marriage. That's the one we're waiting for.
Yeah.
I mean, there are several gay marriage petitions on the calendar for what they call the long conference, the one at the end of September before the court reconvenes. They, of course, don't have to grant any of them. But as Justice Ginsburg said the other day, they're looking to see what the Sixth Circuit does. Right now, that's the court that seems most likely to uphold restrictions on same-sex marriage. So that one, I think, will overshadow all the other stuff that's there. I mean, there are, a lot. We'll also get a better sense, the first week of October when they act on a lot of these pending petitions, and we'll see which one that they take. There'll be there's some more healthcare challenges which are sort of in the pipeline. But I would say that same-sex marriage.
Great, thanks.
And if I could, just before we go, I mean, I think, who the justices are and what they're like, I mean, that is definitely that's a very important part of the job, and it's fun for me. And I would say I try to write about, their personalities in collateral ways, because the justices, unlike other public officials, they'll talk, the less important the topic, the more likely they are to talk to you. In other words, the closer it is to what they actually do every day for their paycheck, the less they want to talk about it because of various, judicial hang-ups that I guess they call rules.
Yeah.
And but when you get into things other than that, so that has often been the way I've tried to get at it. For example, for Roberts, it was a story about using my friend. For Justice Stevens, it was a story I did about his crusade to prove that Shakespeare didn't exist. And for Justice Kennedy, it was related, and some of the other justices, it was about this bizarre hobby that most members of the court have, which is that when they're not working, they like to have fake trials for fun. They put a bunch of fictional and historical figures. Got a great picture of Justice Ginsburg in like an F Troop uniform, court-martial of General Custer, and Justice Scalia putting Napoleon on trial, and the main centerpiece being Justice Kennedy, who does a trial of Hamlet, which he did, and it was great because the one was in L.A. and Mel Gibson came and he played Hamlet once. The only reporter who interviewed Mel Gibson about Hamlet and his true motivations, as opposed to anything else Mel Gibson would get involved in. So those are all very good. And I've got one in the works that's similarly a collateral way to try to get some of the personality out. But I think that the main, the main thing that the Supreme Court press corps can do to benefit the public now, even though getting headlines out is important and getting coverage of what the court decides with oral arguments is important for busy people to have a good summary, I think the main thing that we try to do now, I think this is true for my colleagues at other news organizations, is actually get inside these legal issues in these cases and go to the places that they come from and find out what is really happening beneath the surface. How are these cases originating? How are they affecting people? What is the actual situation on the ground? Because a lot of the stuff that we, that we sometimes talk about that maybe is most evident is really just a convenience service. Because if people want to read the whole opinion, they can read it. If they want to listen to the argument, they can hear the oral argument. And summarizing it now, there are many law professors who give you very good analysis on their own blogs shortly after decisions or arguments. But for the surviving legacy dinosaur media, the main thing I think that we can do, and I try to do, is to do really deep takeouts that go places and find the real issue and the real people behind these stories, sometimes years after cases at the court, sometimes years before it gets there. And I'll just give you one example before I let her get pizza or something. It was just something I sort of noticed in one of these Blizzard press releases that comes out of the Department of Justice, which is I noticed that they were, and this may not be as much of a surprise to people in Louisiana, but they were going back into court to try to get a school district in Mississippi to comply with Brown versus Board of Education, which I found sort of surprising. And it turned out that this was a school district that had never, that still, according to the Department of Justice, not only did it still operate a dual school system, which it had been resisting implementation orders for 50 years, and there are still many school districts that have not yet been declared unitary in terms of desegregation law. But most of them are not actively resisting and fighting every order, every remedy imposed by a district court. In this case, they've been dormant for many years, and the Department of Justice went back into court and pointed out, and it was an amazing case in some ways, because if you could look at it, how you looked at it affected what you made of the circumstance in Cleveland, Mississippi, with a railroad track down the middle, and it was, to me, a very interesting story about the legacy of the Brown case and how its implementation was going 60 years later. And that's not the kind of thing that will come up on a blog post. It's not the kind of thing that the court is putting out. I mean, several justices told me they were stunned to see that there were still a handful of cases where there was active resistance, and yet it was even slightly more complicated than that because of the way the district went out against Curate and sending the story. So those kinds of things are things that, covering the court, I think, are, much as I would be fascinated to find out about love affairs among the extremely sexy people looking at how what they do, matters far beyond the Marble Palace on 1 Street. I think is the, maybe the thing that is most gratifying for people who try to connect that building and its secretive deliberations to the other 300 million people.
That's beautifully put. Well, thank you so much.